Okay, well, I think we'll make a start. So good morning. Welcome to our webinar on the new post-Brexit immigration system. It's great to have you with us. My details are there. If you'd like to link in with me, that would be great. So as I say, we're going to look at the post-Brexit immigration system. What are we going to cover today? We're scheduled for an hour. I'll try and make sure that we're finished in 45 minutes or so. I know very often it's good to get a coffee, have a break before the next meeting, and we've all got a Zoom limit to our capacity on these things. So we'll try and go for about 45 minutes and then allow that time for coffee. We're going to be looking at the new post-Brexit immigration system, and in particular focusing on the key actions that businesses, institutions, employers need to be taking in the run-up to the 1st of January next year. So we'll have an overview of the new system in big picture terms. So just to look at the landscape and the key features in a big picture zoom out way. We'll then focus on the new work visas and the new tradable points, look at how those visas will work, the sorts of roles that will qualify for the visas, and try and work through some examples so you can get a feel for how that will work. We'll have a brief survey of other visa categories and some problem areas, just so that we've got a good overview of the new system, the different options, how it will work. And then we'll focus towards the end on the actions that you want to be taking now. I think that's a particularly important section for us to be thinking about. What do we need to be doing now to get ready for the 1st of January next year? How do we need to be planning? What actions do we need to be taking? Hopefully the technology will stick with us as we go through this. We've got a very large number on this webinar, so fielding questions might be difficult as well as the time constraints. But if you do have a question that you'd like to raise, please do pop it in the Q&A box, and if I can, time allowing and numbers allowing, I'll try and pick off some of those at the end. Great, so shall we have a look just in big picture terms, as I say, on the new landscape that's going to kick in from the 1st of January next year. As we probably know, EEA nationals as well as non-EEA nationals are going to need visas in order to live and work in the UK from the 1st of January next year. The EEA, that includes obviously the EU 27 and also the other EEA countries of Norway, Liechtenstein, Iceland, and on top of that, Switzerland as well. So we're looking at, as is well publicised, an ending to freedom of movement. Effectively, to live and work in the UK, a visa will be required. There will be visa-free travel for what we call visit activities, short-term, non-substantive activities in the UK, but that will be limited to those very limited activities. The new system is going to build on the existing infrastructure. So this is a case really of evolution rather than revolution in terms of the immigration infrastructure. So effectively what's happening is that the existing points-based system infrastructure is being adapted and extended to cover EEA nationals as well. And we'll look at that in a bit more detail as we go through. So with that, the concept of employer sponsorship for most visas remains. So the idea is that for work visas, a person must have a job offer for a specific role with a specific employer. And there's effectively a two-stage process to go through to get a visa. Stage one is the sponsorship stage, so the employer has to take certain actions to sponsor the person for that visa. Once that's been completed, the person then goes and applies for their visa. So that two-stage process. And some of the other infrastructure that we have at the moment, things like the shortage occupation list that I'll touch on later, is also being retained. Significantly, work visas are going to be available for a much wider range of roles than is the case at the moment. So as we'll see, the minimum skill level for a role to qualify for a visa is going to be lowered, and there's going to be much more flexibility around the salary that can be earned. And that's going to be done through a tradable points system where you have to get a minimum number of points as a person to qualify for a visa. And that's going to be through a combination of mandatory points, compulsory ones, and then tradable ones that you can get through a combination of different salary thresholds, education qualifications, and other bits and pieces. And that's going to be a big focus of what we look at today. Good news, there is some good news. There's going to be some streamlined compliance for sponsors and employers, which is great. So as we'll see, some of the compliance obligations that are in place now, things like the advertising process called the resident labour market test, that is being abolished, potentially making it more straightforward to be managing people that we're sponsoring, which is good news. Perhaps less good news is that there is very limited provision for specific sectors. So we're not looking at a system which has got significant carve-outs for lots of different sectors. Quite interesting, we ran an event with the Home Office in one of our offices a year or so ago, and they were feeding back that really the desire of the government is to try and create a system which is not too complicated, not too many carve-outs and loopholes, and a relatively uniform set of rules. And that is what we've ended up with by and large. With that, there's going to be minimal provision for low-skilled and low-paid roles. And again, that seems to be a deliberate decision that's been made by the government in the face of strong lobbying from many sectors to the contrary. So it seems to be, and again, we've had events in our offices with a migration advisory committee that runs the advice for the government on migration matters. And they were saying really the policy drive here is around trying to bring an end to reliance on cheap European labour by businesses, perhaps a perception there hasn't been the level of investment that there should have been, perhaps not paying a high enough wage for some of the work being done. That doesn't necessarily go down well with many industries or isn't necessarily particularly practical, but there's a clear policy decision to have limited provision for low skilled and low paid roles. And we'll look at that in a bit more detail as we go through. Okay, so that really is a very high level overview of the sorts of system that we're going to be looking at. So I thought we'd deep dive and go into a bit more detail about the skilled worker visa. So this is the main work visa that's going to be coming into play from the 1st of January next year. So this replaces the current Tier 2 general visa. It's a sponsored visa and has lots of similar characteristics to the existing Tier 2 general visa. So you have to get a certain number of points to qualify, 70, and I'll look at those in a moment in a lot of detail. The role has to be at RQF level 3 or above in order to qualify for this visa. Now that is a reduction in the skill level that will qualify. So up to now for the Tier 2 visa, it's been level 6. It will be level 3 going forward. That is a deemed A-level skill level role. You don't have to hold A-levels to do the role, it's a deemed skill level. And the way the system will work is that the government will publish, has published indeed in the further details paper, schedules with lots of what they call SOC codes, standard occupational classification codes, that are kind of chopped up into different tiers, and you have to go into those codes, identify the best fit code for the role that you're looking to fill, work out, is it at a high enough skill level? Are you going to meet the minimum salary required as set out in the code, and any other relevant information? So it's identify the role, go to the top codes, and then you work through whether or not it's viable to be sponsoring a person for this visa. This does open it up to a much wider range of roles than the current Tier 2 system. So just to give you a feel for some of the roles that are there now, so laboratory technicians, IT support technicians, paralegals, HR officers, sales administrators, nursery nurses, tool fitters, vehicle mechanics, builders, bricklayers, roofers, butchers, wig makers, if that takes your fancy, teaching assistants, flight attendants, and so on. So a much wider range of roles will be in principle open for sponsorship for this visa, which are not open for sponsorship under the current Tier 2 general work visa. As I mentioned a moment ago, we're looking at a streamlining as well of some of the requirements. So at the moment, as many of you will know, for the Tier 2 general visa, in most circumstances, you have to conduct what's called the resident labour market test, which is an advertising process. It's done in a prescribed manner to show that you can't fill suitable, you can't find a suitable settled worker to fill the role. That is disappearing, being abolished, which I think is great news, really on 2 counts. I think the first count is that it will significantly speed up the recruitment lead-in time. So in most cases, you'll be looking at 4 weeks off the recruitment process compared to what you have at the moment. And in some cases, it will be more than that due to the way the cycles work on applying for this sort of visa. And I think the second reason it's great news is in terms of the compliance issues. So the resident labour market test, the retention of the paperwork from that, the fact that's an issue that's often looked at in audits by the UKVI. But all of that stress, if you like, should be taken out of the process, making it a much smoother, easier process to manage. So some good news in the mix. This is a visa category that will lead to settlement in the UK, so it will get you to that long-term unrestricted right to stay in the UK, and you can potentially apply for that after 5 years, subject to meeting settlement criteria. And this category itself, we anticipate, will have a maximum of 6 years that you can be in it in the UK. There isn't any cap on these visa numbers, so that's more good news. So at the moment, for the Tier 2 visa, there's a cap of 20,700 for entry clearance visas of that type. That cap is disappearing. So you're never going to be faced with a situation of having to sort of compete, if you like, with other employers for a finite number of visas. That's disappearing, so there shouldn't be the pressure on numbers. And an interesting detail that could come out of this is potentially the new system could lead to an increase in inward migration. Remains to be seen how that will work. There are some costs in the mix that we'll come to in a moment, but it won't necessarily be more restrictive for getting visas for people. So I thought I'd look at the key elements of that in a bit more detail. This is probably an area where you've got most of the questions, which is around how the points will work. How do you get the 70 points that you need in order to qualify for one of these skilled worker visas? So you get 50 through the mandatory criteria, which are pretty straightforward. They're there on the screen. So a job offer with a sponsor, 20 points in the bank, great. The job offer is at the right skill level, at least A level or above, RQF level 3 or above, another 20 points, job done. And then there is also an English language requirement at what they call intermediate level, and that's evidenced either through being a national of a majority English-speaking country, there's a list published of those, having a degree taught or research in English, or the fallback position, you go and do an English language test to show that you've got the right skills and get those points. It's a basic English language standard, so you can read basic reports, you can write basic emails, but it's not generally deemed to be an adequate level to fully function in the workplace. So it's not a particularly high level of English standard. The more interesting bit is this element of tradable points. So you've got the 50 points in the bank from the compulsory bit, mandatory element. What about the 20 tradable points? And I've pulled it together here on a table so you can see how it will work. So you effectively get the balance of points, the extra 20 points, through a combination of salary level and other characteristics. So you've got salary level there on the left and other characteristics there on the right. And this is where it gets quite interesting, because effectively you've got much more flexibility in terms of how somebody can get the points required to qualify for one of these visas. It's more flexible than the current Tier 2 system. So you have to meet, in terms of salary, the minimum general salary threshold or the going rate, whichever is higher. So the going rate for a role is set out, published in that SOC code for the role that we talked about earlier. So you have to either meet the minimum salary threshold here, that's 20,480 is the bare floor, or the rate for the job, the going rate for the job as set out in the SOC code. So that's a salary element, and depending on the level of salary, you can get more points. So you have to have at least 20,480 to get in at all, but then as you go up, you get more points depending on the level of salary. The other elements are on the right, and this is around education qualifications, the shortage occupation list, and new entrants to the labour market. So you can get 10 points if you've got an education qualification in a PhD subject that is relevant to the job. So you might think, well, how's that going to work? That is for the sponsor, so for you as a sponsor, to decide and to justify. And in the further details paper the government's published, there's a table at the back showing the potential roles that you could have a PhD in a subject relevant to the job to get those points for. And it's quite a wide range of roles. I think in some cases it'll be obvious if you're doing a postdoctoral research role in a university, then having a PhD in a subject relevant to that job will obviously be fairly easily met. But there may be a wider range of circumstances. Engineering roles are listed in that table, and there may be some roles where having a PhD is relevant to the particular job that somebody is going to be doing as an engineer. Likewise, although PR roles, PR professional roles are listed in the table of roles that could potentially qualify for that 10 points, in reality, it's probably going to be more difficult to be able to justify a PhD being relevant to the job in those circumstances. We await a bit more detail on how that assessment should be conducted. The second one down, the education of qualification PhD in a STEM subject relevant to the job, is interesting. And there's a list again in the schedules to the further details paper the government's published that lists the roles or the sorts of roles that potentially will qualify for these sorts of points. And if you look at it, effectively what it does is bring into play all of the technical assistant roles. So lab technicians, quality assurance technicians, building civil engineering technicians, and so on, mostly technician roles. There seems to be a deliberate attempt to ensure that somebody who's coming into a relatively highly skilled role, where a PhD is relevant in a STEM subject, but they might be relatively lowly paid, can still get the 20 points necessary to qualify. Job in a shortage occupation list, the next one down. So the shortage occupation list is being retained. So if you've got a job on that list that will be published, updated regularly, should be expanded to cover the wider range of roles that the new skill level encompasses, then you get the 20 points for that. And there's going to continue to be 20 points for somebody who's what they call a new entrant to the labour market. This is effectively somebody who's switching from a student visa into a skilled worker visa, or they're aged under 26, or they're working towards certain professional qualifications. If that's you, if you're a person in that situation, then you get 20 points from that. And effectively, there's a lower salary threshold of 70% of the going rate for the job that you have to meet to qualify. So you can have a lower salary to qualify as a new entrant in those circumstances, and you get to come in with the 20 points. That's for an initial 3-year period, then your salary would need to go up after the initial 3-year period. So hopefully you can see there's a mix of different ways in which the balance of that 20 points can be obtained, depending on the characteristics of the person and the nature of the role that they're going to be performing. So just to try and apply that through, because I know it's a bit fiddly to do, I'll try to work through some just illustrations to talk through, so you can see how that works in terms of how you can trade off different points. So if you take an example of somebody who's paid at least 25,600 or the going rate for the job, then obviously they're in, aren't they? Because they get the 20 points just off the back of the salary that they're going to be earning. And of course, they've already got the 50 points from the mandatory criteria we touched on a moment ago. Take a second example. Let's say you've got somebody who's going to be paid 20,480, and let's say that is meeting the going rate for the job. So they're meeting the minimum salary floor required, but they're going to be doing a lab-based technician role, and a PhD in a STEM subject is relevant to that job. Then they're also in, because they get the 20 points from the PhD in a STEM subject relevant to the job. Or third example, let's say somebody is paid £23,040, and that's meeting the going rate, let's say, for the role. They're going to be doing an engineering role in which a PhD is relevant to the job the employer decides. What points do they get? Well, they've got a salary of 23,040, so they get 10 points for the salary, but that's not enough. We've only got 60 points so far. But they've also got a role they're doing, they've got a PhD in a subject relevant to the job that they're doing. They get the extra 10 points for that. So you get 20 points from the combination of salary and education and qualification. We'll take a fourth example. So a person's paid only 24,000 a year. Let's say that meets the going rate again. So they get 10 points, don't they? Because they're above that threshold of 23,040. But that only gives them 60 points. But let's say the job is on the shortage occupation list. They get 20 points for that. And then they've got the points they need. They get 80 points, obviously, in total, combination of salary and a shortage occupation list. Or a final example, Let's say you've got a student who's been offered a job as a vet, for example. They're going to be paid 22,900, and they're switching from the student visa route. They don't get any points for salary because they don't meet the minimum threshold for points, but they are above the minimum required salary for the role because they're actually meeting the 70% they need to. For the new entrant rate, they're switching from a student visa to a skilled worker visa, so they get the 20 points for the new entrant to the labour market, and they get their 70 points that way. It's a bit fiddly. I think the thing that you have to do is you have to identify the role that you're recruiting to, work out the individual characteristics of the person and what's needed for the role. You go to the SOP codes that are published at the moment in the further details paper, probably in other documents later in the autumn, find the best fit code for the role, assess whether it's possible, assess how the points can be accrued, and then decide whether or not you can sponsor a person for the role. You just got to work it through on a case-by-case basis. And it is going to be important to get it right. So the Home Office is going to continue to place a very high emphasis on getting this right, on meeting compliance obligations. Sponsoring a person for a role that doesn't qualify would potentially endanger your sponsor license, could lead to it being revoked. Okay, so that's the skilled worker visa. I thought we'd look a little bit at the intra-company transfer visa, which is another sponsored visa, different to the skilled worker visa, but sponsored visa, so a specific role with a specific employer. This is replacing the Tier 2 intra-company transfer route, but is effectively the same. There's some tweaks to it, but largely the same. So this is designed as a visa to enable you to move people between your international group companies if you want to do so. So you've got overseas companies, you've got staff based overseas, you want them to come to the UK to perform a role. This is the visa that enables you to do that. It also has a route that enabled people to come in under structured graduate programs, but I'm not going to go into that today. There's a minimum salary threshold here. The default floor is higher, so 41,500, or again, the going rate for the job, whichever is higher, and the skill level is staying at RQF level 6, so deemed graduate level jobs. You've got to have 12 months prior overseas employment with the overseas group company, the overseas linked entity. There'll be an exception to that if you're being paid more than 73,900. More than 73,900, you don't have to meet that 12-month overseas prior employment requirement. And there is apparently going to be more flexibility than the current intercompany transfer route. And I suppose if you're thinking this through, you might be thinking, well, what's the benefit to using this visa route over and above the skilled worker visa route? This has got a higher salary threshold. It doesn't lead to settlement, as I touched on the slide there. I think the key benefits are, firstly, you don't have to meet an English language requirement. So if that's a barrier, it's not a problem for this visa. And secondly, there's more cooling off with more flexibility with what they term the cooling off period. So under this new visa category, you'll be able to stay in the UK for up to 5 years in any rolling 6-year period. So it gives you more flexibility to come in and out of the UK on a regular basis to do particular roles in the UK. The skilled worker visa that we talked about a moment ago will have a 12-month cooling off period. So once you've finished that visa, you'd have to stay out of the UK for 12 months before you can come back in again. More flexible with this intracompany transfer route. Key strategic point, as I mentioned, is it doesn't lead to settlement in the UK. This is not a route that you can get to long-term unrestricted right to stay in the UK. So again, if individual circumstances for a person are such that they want themselves and their family to be able to stay in the UK long-term, you'd always want to be looking at the skilled worker visa. So that's the skilled worker visa, the intracompany transfer visa. I thought we'd have a bit of a brief survey of the other main visa categories, just so you get a flavour for what's going to be out there, how the system will work, and then we'll look at some of the practical points that you need to be thinking about at this stage and in the run-up to 2021. The Health and Social Care Visa was launched in August 2020, much trumpeted. In effect, it's just really a rebadging of the skilled worker visa. You've effectively got the same criteria that you have to meet for the health and social care visa as you do for the skilled worker visa, but there is shorter processing times, slightly lower fees, but not a huge difference, and no health surcharge to access the NHS that the migrant has to pay. So it's good news, it's useful. It does cover a wide range of roles. So if you look at the SOC code list that's published, it covers roles from biological scientists, biochemists, radiographers, physios, social workers, opticians, as well as your doctors and nurses that you'd expect. And that's for roles that are in the NHS, in the social care sector, or NHS commissioned service providers. So good news, but not particularly significant. The global talent visa is worth noting, I think, particularly if you're in higher education or research sectors, perhaps life sciences, those sorts of roles. This is a non-sponsored route that opened in February this year. So it's not something that requires employer sponsorship, but gives more flexibility to the person who has a visa in terms of who they can work for and so forth. The two-stage process for this, you have to be endorsed by a recognised UK body, which will vary depending on the role being performed, the Royal Society, the Royal Academy of Engineering and so forth. You have to get the right endorsing body. When you've been endorsed, you then apply for the visa. There are various ways and routes to getting to be endorsed, but I think the main thing that I wanted to flag up is how this is a good option potentially for senior academics, so professor, associate professor, reader type level roles, because effectively the way the endorsement system works is that if you've had open competition for those roles, so an open advertising and assessment process, and you want to appoint a person who needs this visa or wants to go with this visa, they should be able to get automatically endorsed off the back of that open recruitment program. Likewise, if a person's in receipt of a named award or fellowship, they should also be able to get automatic endorsement. So it's a really good option for senior academic roles, research roles that doesn't require sponsorship and gives the person a bit more flexibility for those roles. And that's for up to 5 years in the UK. Just touching on some other categories that's worth noting. So as I mentioned at the start, we're going to continue to have the visitor category for people to come into the UK on a short-term basis to do limited activities up to 6 months at a time. People can come in most cases, and it's intended that EU nationals will be non-visa nationals for this purpose. That means they won't need to get a visa in advance in order to come into the UK. They can simply arrive at entry clearance, explain the purpose of their visit, perhaps provide some evidence in support, and they should be granted entry on that basis. This is for very limited permitted activities, so things like signing contracts, site visits, certain sector-specific activities like presenting research, obviously tourism, seeing family, holidaying, those sorts of things, but it's not suitable for doing what you'd term substantive paid activities in the UK. Once you move into that, that's when you have to start thinking about other visa categories that give you permission to do that. Frontier workers, I know, is a cause of concern for many people. So this is somebody who is an EU national. They're regularly working in the UK, perhaps 2 or 3 days a week, but they're living and they're based abroad. So they come into the UK for a couple of days each week, let's say. How's it going to work for them under the new system? The good news is that there is going to be a new frontier worker permit to enable people to continue to do that. We're still awaiting further details of exactly how that's going to work, how and when applications will be made. It may be that people in that category could also qualify for pre-settled status under the EU settlement scheme, but that is something that is going to be catered for if you've got frontier workers living abroad but regularly travelling into the UK to work for you. Last slide of the other categories, just to give you a heads up on these. So there's a new graduate route that's going to be launching in the summer of 2021 for students who complete their studies in the summer of 2021. This is an unsponsored route and enables Tier 4 students or the the new student route graduates who've completed their studies to stay and work. If you've done an undergraduate or master's, you can be here for up to 2 years. Doing that essentially should be for any kind of work, and PhD for up to 3 years. So a lot more flexibility, I think, designed to try and ensure the UK retains its place as an attractive destination for international students. And people can then switch from this graduate route into, let's say, the skilled worker visa route, rather like people do now when they switch into the tier 2 general route. So in terms of employers, it's potentially a really good route to sort of try before you buy, if you like. So you can take on a graduate without having to sponsor them, see what they're like, whether it's a long-term game for you, and then potentially look to switch them into a skilled worker visa in due course. Other routes are going to remain essentially unchanged. So the tier 5 routes that some of you will be familiar with, like government authorised exchange, youth mobility, sporting creative routes, they're all remaining in place. There might be some consolidation and tweaks, but essentially unchanged. And likewise, more generally for family routes, for UK ancestry, citizenship, visiting the UK, all those categories essentially will remain unchanged. So that's a bit of an overview of the system and the main visa categories. Just some other issues I think that are worth having on your radar. I've talked about how we're going to have a streamlined compliance system, how the caps being taken off visa numbers, all good news. I think the potential fly in the ointment might be around the costs that employers are going to have to bear in order to sponsor people for these visas. So I'll give you an illustration. Take a 5-year skilled worker visa. Okay. You've got an application fee at the moment of £1,220. For most roles, you'll have an immigration skills charge of £1,000 a year, so that's £5,000. And then on top of that, you've got the health surcharge going up from October to £624 a year, payable by the individual, but many businesses cover that. Before you know it, for a 5-year skilled worker visa, what's the bill? Before you even get onto your normal employment costs, £9,340. But it may well be that effectively what the sort of policy drive here is to say, employers, businesses, institutions, if you want people for these visas, the system's there to enable you to sponsor them for a wider range of roles, but you're going to have to pay a significant cost in order to be able to do that. And that may prove to be the downward pressure on migration numbers. Switching rules are going to be relaxed, which is good news. So that's the ability to change from one visa category to another in the UK. So at the moment, lots of visa categories require a person to leave the UK, apply for a fresh visa from outside the UK to come back in. Obviously hugely disruptive for ongoing employment, costly, and a pain in the neck for the individual and the business. The language in the further details paper is that most migrants will be allowed to switch. Won't include visitors. Query whether it will include people on tier 5 visas, the short-term visas, whether they can switch into the skilled worker visa. Watch this space on that, but there should be relaxed switching rules, which I think is really, really good news. And to be frank, common sense, really. What about compliance issues? We talked about how those are going to be streamlined, so you won't have the resident labour market test paperwork, but there is going to be still a strong emphasis on compliance. That is clear from everything that's been published over the past year. It's still very much the policy aim that if businesses and institutions want to have people on visas, they have to effectively go through a self-certification process. And if they get that wrong, pay the costs for that, potentially with loss of a license, which in the new landscape, with a license that's needed for EU as well as non-EU nationals, is catastrophic. There are, of course, questions around, well, how is this going to be policed? Audits have fallen by the wayside with COVID-19, but post-COVID-19, how are we going to be auditing all of the employers in the UK that have licenses? That's a very good question, but the emphasis is still on a high level of compliance. No change with the common travel area, which includes the Republic of Ireland, so there'll continue to be free movement within that. Republic of Ireland, Jersey, Guernsey, Isle of Man, no immigration controls there, which is good news. And there's going to be the phasing out, interestingly, of physical documents. So it looks as though EU nationals under this new system will not be getting physical documents. They won't get sort of biometric cards or endorsements in passports, they're going to be taken onto this new online portal system that's currently in play for EU nationals under the settlement scheme. They'll have their details on that, and it will be accessing that portal to show prospective employers their right to work, landlords their right to rent, and so forth. So a bit of a move away from physical documents, and that seems to be reflecting the general desire of the government to move away from that. Again, probably good news for employers because it reduces that, is this document proving their right to work? It's in an out-of-date passport, it's a funny stamp, all these sorts of questions that you're dealing with at the moment. No right to work documents need to be retrospectively conducted on existing EU staff, at least that's the guidance at the moment. So if somebody starts with you by the end of this year, you've done the right to work checks under the current regime, you don't need to be doing checks in future to establish, say, that they have applied under the EU settlement scheme to obtain status under that scheme. I think watch this space to see whether the government changes that and introduces some form of check, but there isn't at the moment any obligation to do that. And as a trend towards enrolling biometrics via smartphones, that's going to be the case for EU nationals under the new system. And again, an expressed desire to move that way for non-EU nationals as well in future. So using phones to take photos for facial recognition, phasing out the need to have fingerprints taken. The general direction is around more use of technology, more use of online portals, less physical documents and physical appointments. So some of the problem areas and the unknowns that we've touched on a little bit already. So I've already said there is going to be very, very limited provision for low skilled and low paid roles. So there isn't, for example, going to be any coverage for most administrative occupations, for care workers and home carers, obviously a huge sector that relies on relatively low skilled and low paid labour. No provision really for manual labour roles. There is a seasonal workers pilot that's been running. There might be some provision for fruit picking and that sort of thing, but probably very limited in its scope. We'll think about some of the implications of that in a moment, but they are potentially significant if you have certain types of roles that you've historically filled with low paid EU national workers. Costs for employers, as I say, I think it's going to be expensive to get visas for people, and it's not going to be as straightforward as saying you can't simply employ people or sponsor people who are of particular nationalities, because that potentially takes you into race and nationality discrimination territory. So there are some complex and difficult issues to work through there. What about the timescales for applications? We're waiting for further details to be published on that. They're likely to be published this autumn. And the expressed aim is to say that people can be applying for visas for the new system, so from January 2021 onwards, from the end of this year. So perhaps being able to lodge applications in late November, December, say, in order to be ready to start and enter from the 1st of January 2021. And we're awaiting details of how that's going to work, when applications can be made, and that switchover that will probably come in the weeks ahead. Just on the horizon, just to flag that this is the phased introduction of a new immigration system. They've already had some bits, if you like, come in this year, the talent visa that I talked about earlier, and there may be further changes and tweaks in 2021 and beyond. So I don't think we're looking at a complete kind of changeover to a fully formed, fully fledged new system. I think it's going to be potentially more gradual than that. An illustration of that is there is talk of having a non-sponsored, highly skilled worker route being introduced. There's been some skepticism, I think, about the value of that, whether it's needed. I think the Migration Advisory Committee that advises the government has made some comments on that, but it is going to be introduced, it seems, at some point in the future. But I think we can say that's going to be probably of limited scope and not of value or use to most of the roles that most employers will be sponsoring people for or wanting to employ people in. There have been recommendations on the simplification of the immigration rules that anybody who's involved in immigration knows are grotesquely complicated. They're getting added to, gets bolted on, very hard to navigate, far worse than most other types of legislation. The government's looking at simplifying those. Wonder whether that will actually happen. It'd be good news if they did. Needs to be done, but a bit of a watch this space on that. So perhaps the most significant slide for now is to be thinking about, well, what should we be doing now in light of all that we've talked about, the new system, the new categories? What do we need to be doing now in order to get ready for this new system? And I've put a circle there of key actions that I think you need to be thinking about. I think the first one is around sponsor licenses. So we've talked about how you'll need to be a sponsor in order to be able to get people in on the skilled worker and intercompany transfer visas from 2021 onwards. I think the message is, if you haven't got a sponsor license already, and you are going to be looking to employ EU as well as non-EU nationals in the future, you need to get a sponsor license. That is an essential prerequisite. There is likely, I would say, to be a pile-up and delays towards the end of the year as people suddenly realise what they need to do and applications are put in, leading to a huge delay. Just to give you a flavour on that, at the beginning of this year, 28,743 organisations were sponsors. Now, 29,514 are registered. So this year, less than 1,000 extra businesses have registered as sponsors, and you've got about 1.4 million private sector employers in the UK. You kind of get the picture. If you haven't got a license already, I think you need to get one and get that underway sooner rather than later. If you've got one already, I think there's some big questions to ask around, is it fit for purpose? So does it cover, does the original license application you submitted cover all of your sites, your branches, your international linked entities and group companies? Is it fit for purpose, taking into account the wider range of roles and potentially locations that you'll be wanting to employ migrants in? The value of the license is obviously hugely increased in terms of compliance issues. Is your compliance in good order? If you lose your license now, that is potentially catastrophic for you, given the wider number of roles you're going to need it for. If you have already got a license, it should be the case that effectively the system just automatically changes over. There will be changes behind the scenes to enable your license to work under the new system. So your tier 2 general license will become your skilled worker license. Your tier 2 intracompany transfer license will become your intracompany transfer license. And that will be done behind the scenes with some changes, we assume, on the sponsor management system portal. You don't need to, based on what we know at the moment, making any applications to change anything on the system for that. The issue, if you've got a license, is just around, is it fit for purpose on those points I touched on a moment ago. I think the second area is around recruitment timing. So thinking carefully about that, particularly in relation to EU nationals. So if you've got EU nationals in the pipeline to be starting with you, if they can come into the UK, start and be resident here before the end of December 2020, the end of this year, that's preferable to them coming in from January 2021 onwards. Why? If they're here this year, they're covered by the EU settlement scheme, much cheaper, less costly, better for the individual, much better route to settlement in the UK, rather than having to get a skilled worker visa with all of the issues that we touched on and costs that we touched on earlier. So think about your recruitment timing over the next few weeks and months. What about strategic planning for roles? If you've got low skilled, low paid roles that you've filled, what are you going to do about that? And that includes outsourcing, because in the end, if you outsource cleaning, catering, security, those costs are still going to come back and bite you in the end. Are you going to have to think about creative schemes such as apprenticeships, increasing remuneration levels, so you've got increased cost base that pays the wage you need to attract people to those roles? Thinking about, okay, which roles have we got that will qualify for sponsorship under the new system, and planning for that, the likely numbers that you'll need to have to be sponsoring for those sorts of roles. With that, what about your resources? What about your internal HR team and resources? Have you got the resources to manage the system with the expanded number of visas that you'll be issuing? What about training, upskilling of the team so that they understand how the new system will work, they understand how the SOC codes work, they don't make the catastrophic error of sponsoring somebody for a role that doesn't qualify. Upskilling and training is going to be absolutely vital, I'd suggest. And again, budgets with that. If you're going to be looking at 10k a throw to sponsor somebody for a 5-year work visa, where's that resource going to come from? Do you need to be having conversations internally around those budgetary issues? What about your recruitment systems and processes? They're going to need to be rewritten, adapted, changed in light of the new system. Have HR on board with that, understanding what they need to do to manage that system going forward. Existing EU staff, I think, is still vital to get the message out to them that they need to be applying under the EU settlement scheme by the end of June next year. If they don't do so, they're potentially going to be living in the UK unlawfully. Getting good comms out there, perhaps briefing sessions still, advice surgeries, whatever it might be, is vital to ensure that they understand what they need to do to preserve their status and rights in the UK. And the final one around staff based abroad, if you've got British nationals based in the EU, make sure they know what they need to be doing under the equivalent of the EU settlement scheme in the country, the EU country that they're working in. If you've got sponsored staff at the moment who are based abroad, who've gone abroad for COVID reasons, all sorts of issues can come out of the woodwork on that around tax, permanent entity risk, reporting obligations as a sponsor. Are you on top of that? Are you across that? And COVID-19 temporary right to work checks, make sure that if you've done the temporary right to work checks under the COVID-19 exception, that you're still going to be doing the proper checks in due course within 8 weeks of the COVID-19 exceptions ending. Compliance in the new regime is going to continue to be key. All of these issues are issues that we can help with. So if you need help in applying for a sponsor license, we can prepare that for you. If you want help in strategic planning, policies, procedures, audits, training for staff, all that sort of thing is the stuff that we can support you with. So just let us know if we can help you in any way in any of that. And that's all I wanted to say proactively. Thank you very much for joining us. I said it'd be about 45 minutes or so, and we've been that. I will just try and pick out a couple of questions from the feed, if you'll bear with me, and pick out those, and then we'll finish certainly in the next 2 or 3 minutes or so. So let's just have a look at the questions that have been picked up. So someone said, if you meet the 70 points, is that a given, or can you still be refused? I mean, there is the ability to refuse someone's visa application on sort of general grounds, so perhaps due to criminal records or past failures to comply with visa terms. So sort of linked to the individual, there is always the risk that a visa application may not succeed, but provided all of that's in good order and the person gets 70 points under the new points-based system, if they're applying for skilled worker visa, there shouldn't be a problem in the person being given the visa. Someone's asked a question about full-time hours or pro rata hours. The way it works is that you can pro rata the going rate for the role, but that's always going to be subject to the minimum floor threshold of, I think, £20,040 from memory off the top of my head. So you can, so let's say the going rate is £30,000 a year, but the person is going to be working part-time such their salary is going to be less than that. They can have it less than that, provided that prorated the salary full-time would be the going rate, but the actual amount that they receive in their pocket must still be at the minimum salary floor. I think it's 20,040 from looking at the table or above. So there is provision to enable people to be sponsored for part-time roles, but you just have to work through the salary calculations quite carefully on that. Someone's asked, can somebody transfer on a tier 5 visa to this scheme? I assume they're referring to the skilled worker visa. We don't know yet is the answer to that question. So as I say, there's mention in the further details paper about relaxed switching rules. So it may be that people will be able to switch from tier 5 to the skilled worker visa under the new regime in a way that they can't at the moment switch from tier 5 to tier 2 general, but we're still awaiting the detail of exactly which categories will qualify for that switch. Someone's asked, where can we find a list of jobs and roles to ensure that you comply with the traceable points? At the moment, the place to go is the further details paper that's published on the gov.uk website. There's a document there. At the back of that, there are a series of annexes where they list the tables, and you can identify the role that you're recruiting to, find out which top code it's in, what the salary thresholds are in, whether it potentially qualifies for the STEM, PhD, extra points, whether it's in a category that needs to qualify for one of the nationally published pay spine and bands and so forth. So that's the document to look in at the moment, and then maybe further documents published later this year. There are a lot of questions from a lot of people on the sessions, so I'm only going to be able to pluck out 2 or 3 more before we finish at 5:02. If an employee has settled or pre-settled status, does that mean they don't need a visa? That's correct. So if somebody has got status under the EU settlement scheme, that is the immigration track, if you like, they're on. The best thing about immigration law is always to think about it in different tracks that you're on. If you've applied and got status under the settlement scheme, that is the basis of your right to stay in the UK. That is your route to get settled status, your long-term unrestricted right to stay in the UK, rather than have to go through the new skilled worker route, let's say. Would this apply to self-employed people? Somebody has asked. We are waiting the details to be published on that. We haven't got the full policy guidance. In general, the way it works for sponsored visas are that it's envisaged that the person will be employed by the sponsor and certainly under the controlled direction of the sponsor. It's not an absolute hard requirement that somebody can't be self-employed if they are doing work for a sponsor in a specific role, subject to all of those requirements. But I'd generally be uncomfortable with that. We'd have to check what the guidance actually says, and it's difficult to envisage as somebody who is self-employed in most cases will be meeting the requirements to be under the direction and control of the sponsor in the way that the category envisages. Someone's asked for clarity, if you have an existing sponsor license, do you need to apply for a new sponsor license? No, you don't. If you've got an existing license, that should be good for the new system. The changes behind the scenes should take place, but you need to think, is your current license fit for purpose under the new regime? So if you haven't got, for example, a tier 2 intra-company transfer license, do you need to apply for an intra-company transfer license? Does the license cover your different group entities, your different sites and locations in the UK where you want staff to be based? So a review of your current license should still be conducted. A couple of questions around the new entrant rate to the labour market. Let me just pull that back so I can explain that. Perhaps I didn't explain it as clearly as I could have done. So how does that work, the new entrant rate? You get 20 points if you qualify for what they call being a new entrant. That is somebody who will be either switching from the student or the new graduate route, or is under 26, or is working towards certain recognised professional qualifications, perhaps sort of chartered qualifications, or directly going to certain postdoc positions. So there are those 3 ways you can qualify for the new the 20 points for the switch from being a new, not switch, from being a new entrant. You get 20 points, and you also have to be meeting the minimum salary threshold, which is going to be 70% of the going rate for the job. So if your salary is 70%, that you're going to be paid of the going rate for the job stated in the SOP code, and you fall into one of those 3 categories, switch, the under 26, or working towards professional qualifications, you can get 20 points from the new entrant route. Final question, and then we'll probably call it a day. What's the cost of a sponsorship license? Let's deal with that. They're published online. So if you're a small sponsor, a charitable sponsor, the definition of that is online. The full definition escapes me. The cost is, I think, 500 and something, maybe 536 for the license. It's just under 1,500 if you don't qualify for the small charitable sponsor license. So the worst case scenario is 1,500 for that, but there are, of course, then the costs for the extra bits and pieces to do with sponsoring each individual person that we've talked about on top of that. So I think we'll call it a day there, but thank you very much for joining us. I hope it's been useful for you. If we can help in any way in helping you navigate through what is, I know, a complex new system that you need to get right, please do get in touch with me. It would be great to hear from you. Thank you very much.